It's 10 o'clock, Saturday night. Marcus is northbound on I-25, heading home from dinner in Albuquerque. New Mexico has one of the worst drunk driver rates in the country. And tonight, that statistic becomes personal. A pickup truck drifts into his lane. They collide. The other driver blows a .18, and cops take him away. Marcus heals, calls the insurance company, takes their offer, and moves on. And when nobody told him, a drunk driver accident in New Mexico isn't just a regular claim. It can be worth significantly more. And there's a second party that may also owe him money that most people never even think to pursue. So let's talk about punitive damages first. In a regular car accident, what you're going after are compensatory damages. They're the money to get you whole. Medical bills, lost wages, pain and suffering, what you're owed because someone hurt you. When a drunk driver hits you, there's a second category on the table. It's called punitive damages. And here's the key difference. Compensatory damages are about getting you made whole. Punitive damages are about punishing. The legal purpose is to penalize the at-fault driver and send a message that this kind of behavior isn't acceptable. A judge or jury can award them on top of everything else. Now, punitive damages don't come with every accident. They're not automatic. In New Mexico, punitive damages are reserved for conduct that is more than ordinary negligence, including conduct that is malicious, willful, reckless, wanton, fraudulent, or in bad faith. Getting behind the wheel drunk, especially with a high BAC or prior DWI history, is exactly the kind of fact pattern that can support a punitive damages argument. They're not automatic though, but the facts in a DWI case often can get you there. I've seen stuff on the other side of this. When I was doing defense work representing insurance companies, DWI cases were handled differently. There's a reason for that. Insurers know that when a defendant was drunk, the damage exposure goes up. They know punitive damages are in play. And so the internal response is different. The adjuster is not going to volunteer that information to you. That's a gap most accident victims never even knew exists. So how are punitive damages calculated? There's no set formula. The court looks at how egregious the conduct was. They consider the defendant's financial situation, and they look at the impact of the victim. The goal is to make the punishment actually sting. A $1 million award against someone who has nothing accomplishes nothing. It has to be a number that gets someone's attention. In DWI cases, the blood alcohol level matters. The higher the number, the worse the conduct looks. Prior DWI history matters too. A first-time offense is different from someone who's done this before, right? All that goes into what a jury might award, and frankly, what an insurance company is willing to settle for before it ever reaches a jury. Now let's put a real number on it. Say compensatory damages in a case, like Marcus's case, come in at around $120,000. That's medical bills, lost wages, pain and suffering. That's the baseline. Now layer in punitive damages. The driver blew a .18. He had a prior DWI in his record. The jury decides this was someone who knew exactly what he was doing and chose to get behind the wheel anyways. They can award an additional $150,000 on top of that $200,000. More, depending on how bad the facts are. So the total claim doesn't just nudge on a little bit up. It can double, right? That's the practical impact of punitive damages. That is what changes the math in your case. Here's the thing. Most DWI accident cases do settle, but knowing punitive damages on the table changes what you can demand in that settlement. It changes the whole conversation. At the same point, you need someone who knows how to make that argument. A lot of injury claims get processed like standard accident cases because the adjuster treats them the same way. If nobody pushes back, punitive damages never come up, period. Now, there's a second piece that most people miss entirely. That's called dram shop liability. That's the legal term. Now, dram is an old word for a bar or tavern. What dram shop law says, in plain terms, is that if a bar or restaurant served alcohol to someone who was visibly intoxicated and that person then drove and hurt someone, the bar may also be liable for your damages. New Mexico has a dram shop act. That means the drunk driver who hit you may not be the only party responsible. The bar that kept refilling his glass when he could barely stand up, they may share liability for what happened to you. Does that apply in every DWI case? No. New Mexico statute focuses on whether the person was intoxicated, whether the intoxication was reasonably apparent to the licensee, and whether the licensee knew from the circumstances that the person was intoxicated. In practice, that means observable signs and surrounding facts matter. One beer doesn't generally get you there, but if someone was visibly impaired and the bar kept serving, that is a viable legal claim. Now here's why this matters practically. Drunk drivers often carry the state minimum insurance. In New Mexico, that's not a lot of coverage. A dram shop claim can still matter because it can add another legally responsible party. New Mexico does cap some dram shop liability by statute, depending on the circumstances. So that's not always an unlimited path to recovery. And the value still depends on the facts, the injuries, and available insurance. But in a serious case, adding another responsible party can make a real difference. If you or someone you know was hit by a drunk driver, drop a comment below. I read every one. And one of the first questions I want to answer in a case like this, where were they drinking before the accident? Were there witnesses? Is there surveillance footage? Receipt records? This is time sensitive. Surveillance gets overwritten. Receipts get deleted. The evidence window for a dram shop case is really narrow. The longer you wait, the harder it becomes to build. If a drunk driver hit you, start thinking about that question right away. Where were they before this happened? Because if we can answer it and prove the bar overserved them, we may have another legally responsible party to your case, subject to Mexico's dram shop law. Now, some surveillance systems can overwrite footage within days, and retention periods are going to vary widely. And once that window closes, it's often gone. What you're looking for in that footage, though, the timestamp of when the driver arrived, how long they were there, how many rounds were served at their table. Credit card receipts in the bar can show the tab and the time. Staff can be identified and asked what they observed that night. Other patrons who watch them stumble out into the parking lot can give you statements. In New Mexico, visibly intoxicated isn't a vague feeling. It means observable signs that a reasonable person would notice. Slurred speech, trouble keeping balance, glassy eyes. If the bartender should have seen these signs, the law says they were on notice. And if they kept pouring anyways, that is the foundation of your dram shop claim. There are 4 things you should do right after a drunk driver hits you, and most people skip all of them. 1, find out where that driver was coming from before the accident. The police report may have notes. Witnesses at the scene may have heard him say something. Write it down before those details fade. 2, if you think the bar was involved, tell your attorney that day, not a week later. That surveillance window is real, and once it closes, it closes. 3, follow the criminal case. The DWI investigation can generate important evidence, which includes BAC results, officer observations, witness statements, and court records. Some of that evidence may help the civil case, depending on admissibility rules in the court and how the criminal case is resolved. 4, do not sign any settlement offer until you understand whether punitive damages are in play. Once you sign, the conversation is over. And so, getting the full picture first, before you settle anything, that is how you protect what you're actually owed. So here's the full picture. Drunk driver cases in New Mexico can come in higher than standard PI cases for 3 reasons. Punitive damages may be available on top of your compensatory award. A dram shop claim may add a second, better insured defendant, and the criminal case runs parallel, which means a criminal case creates useful evidence for the civil case. But how a conviction, plea, or court record can be used depends on the charge, and the plea, and the evidence rules. The point is that the state is building a record, and that record can matter to your case. Now, I won't pretend these cases are simple. There are coverage disputes, there are defenses that insurance companies don't hand over punitive damages without a fight. But the leverage is real, and if you don't know how to ask for it, you won't get it. That's exactly what I mean. I've seen the internal calculus. I know how insurers approach DWI cases when they think that plaintiffs' attorneys know what they're doing versus when they don't. When you have someone who actually raises punitive damages and investigates dram shop liability, that conversation changes. I've seen it from both sides. If a drunk driver hit you or someone in your family in New Mexico, don't treat it as a regular accident claim. The law gives you more tools in that case. Make sure someone on your side knows how to use them. Before you talk to any insurance company after your accident, there are specific things you should never say. I break down exactly what those are in the next video in my series. If you need to talk about your situation now, I'm Damon Hudson at Hudson Injury Law. Give me a call, 505-416-4150, or visit us at hudsonинjurylaw.com. Consultations are free. And if you or someone you know was hit by a drunk driver, drop a comment below. I read them all, and hopefully I can help you.